Excuse me about that. Okay. Hey everyone. So, welcome to our lecture videos. So, the lectures for this class are going to kind of be, the later ones are going to be more in depth, but these early ones, especially the first three chapters, three lecture videos, are going to be pretty much going over things that we've talked about before in Intro to Criminal Justice and things like that. But we'll still talk about some of those concepts here and there. So, obviously, this is lecture one. So, we're talking about Introduction to Criminal Law. And so, this is the textbook. This is the PDF version of the textbook that I've included online on Blackboard. And there's also the web version. I'm using the PDF just because it's easier for me to record when it's offline. Anyway, so the very first thing that we got to do is define what a crime is. And obviously, if you're in criminal justice, I would assume that you know what a crime is, but our textbook here gives us a definition from yourdictionary.com 2010. What is a crime? It is an act committed in violation of a law prohibiting it or omitted in violation of a law ordering it. Basically, you did something you weren't supposed to, or you didn't do something you were supposed to do. That's really the basic definition of what a crime is. And of course, something that we talk about in chapter 4, we've talked about before in other criminal justice classes, is that the big important piece is that there are elements of crime. There are parts of every crime. And some of that we have right here: criminal act, omission to act. But we also have to consider the intent, whether or not the individual has malicious intent or if it's accidental, that sort of thing. Obviously, when we talk about some of the case study things, we will get into how intent plays through that. But really, there's a few things that need to be talked about. One thing is that laws are not static. They're supposed to change, and they do change. And it's part of the reason why we have arguments about constitutional law, because laws aren't supposed to be, this stagnant one thing. They're supposed to update as things change, but they're supposed to be pretty, solid. And we'll get into that when we talk about those things. But one thing to note specifically about the United States is that, we have a federal government that has federal laws, but we also have 50 individual states that all have their own state government, which means they have their own state laws. So laws can vary between state and state. They're widely and wildly different. But the important thing to remember is that because we're a democratic republic, because we're a democracy, because laws are developed by people, this means that those people that make those decisions, those laws that they put forward, come from their religious, their cultural, and their historical value systems. So remember that, laws change based off of who makes them, that kind of thing. So that's really what I wanted to emphasize with at least part 1.1, the introduction to it. But I really like this piece and I want to highlight it. Law is not exact like science or math. Try to become comfortable with the gray area rather than viewing situations as black or white. That is one of the biggest things about criminal law and law in general. Things are not always just black and white. There's always little wiggle rooms and exceptions, and that's why they consider intent. That's why they consider the crime. That's why they consider who was impacted, victims. All these things play into that. So obviously with our textbook, there is a key takeaway, just real quick, not lecture, but more about the textbook. There's a key takeaway box at the end of every section that tells you what you should get out of the class. And there's also exercises with, they have a question and they usually have some kind of actual court briefing and we'll talk about those in a bit. Anyway, so criminal law and criminal procedure. Just real quick, what's the difference between criminal law and criminal procedure? Well, criminal law is a rule, something that is put in place and is what you follow or don't follow. Criminal procedure is the process in which something happens. And I really want to emphasize this example that they have in this chapter is fantastic and really highlights the difference. So, criminal law defines the rights and obligations of individuals in society, whereas procedures how they go through. So, an issue of criminal law and an issue of criminal procedures, all related to the same example. So, in the textbook, we have Clara and Linda go on a shopping spree. Linda insists that they browse an expensive department store. Moments after they enter the lingerie department, Linda surreptitiously, places a bra in her purse. Clara watches, horrified, but does not say anything, even though a security guard is standing nearby. This example illustrates two issues of criminal law. The first is, what crime did Linda commit when she shoplifted the bra? And then secondary, did Clara commit a crime when she failed to alert the security guard to Linda's shoplifting? Obviously, you're going to know more about that as you read, but yes, there are some issues, not just with the fact that Linda shoplifted, but that Clara did commit a crime. She was an accessory to a crime by not turning someone in. Now, we're going to take this a little step forward with how procedure comes up with an issue. So let's assume Linda and Clara attempt to leave the store and an alarm is activated. Linda begins sprinting down the street. Colin, a police officer, just happens to be driving by with the window of his patrol car open. He hears the store alarm, sees Linda running, and begins shooting at Linda from the car. Linda is shot in the leg and collapses. Linda is treated at the hospital for her injury, and when she is released, Colin arrests her and transports her to the police station. He brings her to an isolated room and leaves her there alone. 12 hours later, he re-enters the room and begins questioning Linda. Linda immediately requests an attorney. Colin ignores this request and continues to question Linda about the reason the department store alarm went off. Whether Colin properly arrested and interrogated Linda are criminal procedure issues beyond the scope of, obviously, the textbook, but this is an example of how criminal law issue, did Colin commit a crime when he shot Linda in the leg? So, consider that criminal procedure is focused on the inner workings of how law is supposed to be and is operated. So, just think about it. He just happens to hear it. He sees a person running away, shoots them, brings them in for questioning, and lets them sit in a room for 12 hours before doing anything, and ignores the request for an attorney and continues to question. Is this following proper procedure? Well, just keep that in mind. The answer is no, but that's where we get into the gray area. All right. So this class, our focus is on criminal law, and I did say we will talk a little bit about civil law. Obviously, we'll talk about it here, and we'll talk about it in some examples as we go. But we need to understand what the difference between civil law and criminal law is. So, a very brief overview breakdown. Civil law is between two parties, two individuals, or two companies, or whatever it may be. It's two areas. You break them down. It's this person here, this company here, this company here, this group of people here. Civil is always concerned with some kind of financial payback. You get something for damages or something that happened. That's what civil is all about. Criminal law is individual versus government body. And so government body can be state government, local city government, federal government. It can be all these larger things. The idea that you committed a murder, yes, you harmed an individual, and that family could sue, go to civil court and get damages received. But the criminal side of this, the criminal law aspect, is you broke the law that says that you do not harm another individual and take away their life. You did that, therefore, you have broken a rule of the government, so now it is a case between the government and you. That's really the big difference between civil and criminal law. Um, any crime show, or rather not crime show, but any like daytime courtroom show, like the classic Judge Judy, Judge Joe Brown, all those are civil suits. Those are all civil law cases. And they're not really, but the gets into nitty gritty semantics that aren't relevant to this. But that would be civil suits. A criminal suit is, following someone who killed someone, potential attacks. We're talking terroristic attacks, things of that nature. Our textbook brings up a very good example that it ages me and it might age some of you in the class, but yes, there is a thing of victimless and harmless crimes. Technically, there's still there's breakdowns, and this is a nice chart that breaks that down. But what I really want to focus on is this: law and ethics, the O.J. Simpson case. So, if you're too young to remember, way back when, O.J. Simpson was on trial for murdering his ex-wife, and I believe may have been boyfriend. I don't remember. It's been a long time since I've gone into this case, and this just kind of came up, and I'm like, oh yes, I forgot about this. Because of the differences in how those laws and how those cases are approached, the criminal case for O.J. Simpson, he did not have to testify during that case, and therefore he was acquitted. So he got away with murder at the criminal case level, at the criminal law level, because there was not sufficient amount of evidence without a testimony from him, and so he got away. However, civil suit, where the family, the remaining living family, sued based off of damages, in a civil case, you don't quite get the same freedom to say, yeah, I don't have to testify. It's a lot harder to get away with that. So he had to testify, and that proved that he did do it, or at least was directly responsible, aka, while I can't say you did it, you definitely are the reason it happened, end quote. He had to pay. So this is where we get this weird dichotomy of civil versus criminal have different standards, and so people can get away with a lot of things. And so I don't want you to think like, oh, I'm going to learn how to get away with murder. That's not what we're talking about. The important piece to take away from this is that, in particular, criminal law has a higher standard of proof. It's a higher standard that you have to prove beyond a reasonable doubt that an individual is guilty. It's meant to make sure that someone doesn't get sent to prison when they're not supposed to, and we'll deal with that issue in a bit. But it does lead to issues like this. Remember, gray areas. Doesn't matter that it's a black and white issue, and we're like, yeah, this is totally you shouldn't do this. Criminal law is very gray. All right. So next thing that the textbook talks about is the breakdown of how we classify crimes. The term is grading crimes. So it's classified from most severe, most serious, with the highest level of punishment, all the way down to nothing. And it's really, it goes from felony to misdemeanor to felony misdemeanor to an infraction or violation. And so, real quick, just to go over, felonies are the highest. These are the ones that, you did something really, really bad. They're really serious. They're oftentimes dangerous. So they're things like, arson that has led to more than just damages to a building. We're talking murder. These are the big ones. So if you've committed a felony and you're found guilty of a felony, this is where you have prison time, decent amount of fines, potentially execution or death row, and even there's alternate sentencing, which is a whole nother issue about this, and we'll talk about it when we get a little further in the book. But felonies, top level. Misdemeanors, these are less serious. They're still serious crimes. This is where arson that doesn't take a life but just does property damage. This is more on the misdemeanor side. Yes, it can bounce between, so it technically be a felony misdemeanor. We'll talk about that in a minute. But misdemeanors, they're lower than felonies. They're typically, the punishments are like jail time, fines as well, that kind of thing. Like I said, arson is really more of a felony misdemeanor. These are things that can go either way. It's really up to the court to decide what side it's on. Is it more of a felony or is it more of a misdemeanor? Arson is the perfect example of this. And then obviously the lowest level, the least serious, is infractions. These are what's called violations. These are things like traffic tickets, speeding, jaywalking, disturbing the peace. Essentially, technically sex work falls under infractions or violations, even though it's in a weird place where sometimes it's a misdemeanor. The idea is that they're not serious. Typically, you don't get any kind of jail time for an infraction or violation. It's usually just, maybe a sit and lock up for a few hours and then a fine, and that's it. Realistically, infractions are not serious offenses. So it's important to note that they're not super like bad and big things. So the chapter goes the purposes of punishment, and we spend some time in Intro to Criminal Justice about the idea and theory behind how we operate a justice system. How, when you get to the end, is it punishment? What kind of things does an individual have to do? So why do we punish? And that opens up a very big potential discussion question. And I personally would love to hear some of your thoughts on the theory of punishment and the types of punishment that we have. And we'll talk about the types here in just a moment. But so the whole idea is that punishment is supposed to have this larger goal in the criminal justice system. It's supposed to be either for deterrence, incapacitation, rehabilitation, retribution, or restitution. So deterrence is to deter or prevent repeating or prevent it from happening or decrease that. Incapacitation is to hold them accountable. They are incapacitated. They're unable to do any more crime. Rehabilitation, this is supposed to be the end goal of the juvenile justice system. That's currently being questioned. We are on the tipping point of the pendulum for the larger criminal justice system for rehabilitation. We're getting back to an almost retribution point, so we'll see where we are, but we'll talk about that in just a second. But rehabilitation is the idea that you help someone get over whatever it is that led to them being a committing said crime, and so we deal with that. Retribution is the classic eye for an eye kind of concept where you are doing it to get some kind of payback. And I don't mean like something paying you back, because that's restitution. Restitution is getting paid for that loss. Retribution is eye for an eye. You did this, I get to take this away. So in general, those are the goals of punishment. And punishment is a weird word because it has that negative connotation, but we're talking about it in a general sense where it isn't necessarily negative, because punishment could be placed in a mental health facility to get help for someone who has mental health issues and was found guilty of committing a crime. Is it punishment that they're getting help? No. But do we call it punishment because that is the end result of their action? Yes. So when we talk punishment like this, just remember that term, taking away the negative connotation, it's just the result of their action. And the chapter breaks down specific versus general deterrence. Obviously, general deterrence is just less crime. Specific deterrence would be, higher punishment for a certain crime, should see that particular crime goes down, that type of thing. We did talk about incapacitation. We talked about rehabilitation. Like I said, I'd be interested to see where we are in the specifically between rehabilitation and retribution, because that seems to be the big thing, especially in America, that we tend to get into. All right, and then the last section of this chapter, before I talk about what else is cool about this textbook that you'll get. So the sources of law, and this is like the first 3 weeks of Intro to Criminal Justice is just sources of law, because there's so much. So I'm not going to spend a whole lot of time talking about this at all either. So obviously this first video, like I said, this first lecture, it's long-winded because I'm talking about the textbook as well, but it's going to be a very brief overview. If you have questions about this and you need more information, or you need me to explain more something, let me know. Say it in your weekly meeting or set up a special meeting about this. Be glad to work through it. But anyway, so obviously, if you took Intro to Criminal Justice, you know the number one source where most of our laws and our beliefs come from is the Constitution, the constitutional law aspect. This is the high level. This is the these rules say this, and therefore we follow this. Constitution is up there, so is the Bill of Rights. So these are the important big pieces. That's your takeaway. If you want to know what kind of laws people always have to follow in the United States of America, look at the Constitution. Those are the laws that we specifically always follow. Then obviously the next level down, if there is a level, is statutory law. We talked about statutes in Intro to Criminal Justice. Not a whole lot, because it's kind of confusing for a lot of people. But what a statute is a written, published law. It is a law that has been voted on, typically either by state government, local government, or Congress. These are the laws that aren't the Constitution, but they're ones that typically people also follow for an area, or they know, and it's because they're the ones that people voted on. This is why we have issues like originally Proposition 8 and things like that came up, where they were voting on whether or not something was constitutional, or whether or not this was legal or not. So statutory laws are all essentially coming down to written laws that were voted to be a law in an area. Um, so obviously, constitutional law is the top, and the biggest thing about a statutory law is that it cannot conflict or attempt to conflict anything that's in the Constitution. So this is an issue that comes up where if someone tries to make a law that goes against a constitutional belief, like the freedom of speech, all of a sudden that law does not get approved and is thrown out because it goes against the Constitution. This is a weird one. There's administrative laws and ordinances. So these are things like individual groups like the FDA, the FCC, the FTC. Sorry, took me a minute. As well as like presidential things like that. Like these are the more or less what individual government agencies or high level administrative individuals say. They just say, yeah, this is what we're doing. This is the law for us. This is things also like, what is it? EPA, Environmental Protection Agency. Don't know why it took me a second to think of that. They can make administrative laws and ordinances about pollution. They're not constitutional laws, they're not statutory laws, but they're administration laws. The Environmental Protection Agency said you can't do this, so it is a law. Obviously, ordinances are a little bit different than administrative laws. Ordinances are just, there's statutes at the city county level, and so they don't need the whole state's legislature to vote on it. It's just the local municipality. So the Model Penal Code, just very short history. 1960s, legal scholars, lawyers, judges, they came up with an idea of just a standard set of criminal statutes that all states could adopt and should adopt. And so this essentially became the Model Penal Code. It is just a list of statutes, but these are the ones that like you go state to state and they all agree on it. It's not like the old school drinking laws where up until the late 1980s, every state it could be 21 in PA but 18 in New York. Heck, it could be 17. Like, Model Penal Code is the idea that, oh no, it's universal across the board. Everyone can follow this. So this is one that we haven't talked about in Intro to Criminal Justice, and it's relevant for us. And obviously, you can see it's not a big definition. It's not a big section, partly because we're going to talk about it a lot. And case law. Case law is just judge rulings. These are very much how we get precedences, and we're going to talk about that here in just a moment. But case law is, if a judge rules on the facts of a particular case, they create case law. That means we follow that for time and time and time and time again, which comes from English common law, which this is the deep history part if you want to know more about it. We talk about it in Intro to Criminal Justice, but English common law is from the early days of British justice systems, and it was specifically when there were different areas, villages, things of that nature, and they needed rules. There was no rule because there was a king of the country, but there were lords and dukes and whatever that ruled their different areas and domains. So common law, English common law, was what are a unique set of laws that everyone can agree on. It's a uniform system. But a lot of criminal justice systems, not just the United States criminal justice system, but several around the world, actually use English common law as a basis for building out those. So it is important, it is impactful, and it's just important to bring it up that this is the big one. Obviously, a lot has been redone and updated and things of that nature, but we still go back to it. Um, and so the other thing we have, yeah, I didn't pass it yet. Stare decisis and precedent. I did mention precedent. Um, the whole concept behind stare decisis and precedent is that if something hasn't been done before and you're not sure how to make that call, the judge makes a ruling. That case law will then become what is precedent. Their stare decisis, their decision, their very first go, their English common law says, okay, cases similar to this did this, so this is going to be my ruling. This is what I think. And then everything else after that will look back and say, this was the precedent that set it. That's the idea. The whole thing is you look back at a previous version or someone else that did something similar and try to come to terms with what it is. And so we're going to talk about precedent. We're going to talk about statutes. That's going to come up a lot. And obviously, Constitution is going to come up a lot. Hopefully, as I find more case studies and stuff for you to look at and for us to discuss, we'll get into some more administrative law stuff because that's going to be interesting as well. But yeah, so this is just, like I said, a very brief breakdown. Pretty much all this stuff is things that we have talked about in Intro to Criminal Justice. I just want to make sure that you have that basic understanding in this very first lecture video. In that way, as we get into the actual content, we can get into bigger pieces. So that is something else that I do want to talk about in just a second. But so at the end of every chapter is this end of chapter material. It gives a full summary of all the sections. It gives you some extra assignment type things to work on if you really are interested. There are cases that they have links to. I've checked a couple of them. They seem to all be working. If something's not working, let me know. Interesting articles that are related, websites, statistics, as well as answers to the exercises from the chapter. The end of the chapter is a really good resource. I encourage you to use it. Yeah, but that being said, I will tell you right now, I'm not going to read through every single chapter. I'm not going to have 3-hour lectures going over line by line of the textbook. That is not teaching, that's reading. Notice I went briefly through, as we are now in criminal law, this is technically the third class in the criminal justice series of classes. We are going to touch on the key points, the key ideas from the chapter. We're going to look at examples of cases. We're going to talk about what it means, how to process, things of that nature. So that's going to be the focus. But like I said, these first couple weeks are really going over content that has been covered before, ideally. Anyway, thank you very much. Hopefully this one wasn't too boring, and I hope it wasn't too fast for you. Please let me know whether it was too fast or you needed more or anything of that nature. Let me know. It's the only way that I can help you. But yeah, that's all I have for this lecture video. Sorry it's late. I will definitely get a lecture video for chapter 2 up as quickly as possible. But until then, have a wonderful day, wonderful evening, wonderful night, wonderful morning, wherever it is you're watching this. And I'll talk to you soon. Bye.